Good afternoon. I am delighted to welcome you to Private Rights of Action, How Consumers, Workers, and Businesses Are Fighting Corporate Power in the Courts, sponsored by the American Economic Liberties Project and the Committee to Support the Antitrust Laws, or COSAL. I'm Pamela Gilbert, a legislative counsel for COSAL. We are a nonprofit organization made up of law firms and other businesses that works to support, preserve, and protect vigorous private antitrust enforcement. COSAL has been fighting for over 35 years to protect the strong private right of action contained in the federal antitrust laws so victims can be compensated and wrongdoers held accountable. AALP, our partner, is a nonprofit that promotes policies that counter the trend of corporate concentration, including the rigorous enforcement of the antitrust laws. You will be hearing later from Lee Hepner, Senior Legal Counsel for AALP, who will moderate today's panel. We have an esteemed and experienced group of panelists who will discuss the ways in which private antitrust enforcement strengthens overall antitrust enforcement and takes on corporate power to protect consumers and small businesses, and what lawmakers can do to empower private rights of action. But first, I have the great privilege of introducing you to our leadoff speaker, Hetal Doshi, Deputy Assistant Attorney General overseeing the Antitrust Division's civil and criminal litigation efforts. In this role, she's managed the creation of the Litigation Program, an organization comprised of seasoned trial lawyers with backgrounds in prior government service, plaintiffs' litigation, and private practice. In 2014, Hedl joined the Civil Division of the U.S. Attorney's Office for the District of Colorado as a member of the Department of Justice's Financial Fraud Enforcement Task Force. In her early tenure as an AUSA, Hedl led investigations of global investment banks for their role in the 2008 global financial crisis. Those investigations concluded with historic multi-billion-dollar resolutions. In 2016, Hedl moved to the Criminal Division of the U.S. Attorney's Office, where she prosecuted complex white-collar crimes, lots of fraud, including securities and investment fraud, cryptocurrency fraud, healthcare fraud, bank fraud, fraud in connection with the sale and marketing of consumer data, and public corruption. She served as the international law coordinator for the District of Colorado, which required her to interact with foreign law enforcement agencies to assist with international criminal investigations. And she also led efforts in Colorado related to hate crimes and civil rights. Hedl is the recipient of the 2016 U.S. Attorney's Award of Excellence for her work with the department related to election monitoring and the department's Civil Division's Special Commendation Award for her work on historic data marketing investigations. Prior to her time with the department, Hedl was a litigator at 3 international law firms in Denver, New York, and Atlanta. In private practice, she focused on government investigations and complex commercial litigation across a variety of industries. And during her legal career, Hedl spent a year in Nairobi, Kenya, where she assisted with efforts to implement a then new constitution, as well as supported human rights advocacy and education efforts by local and international NGOs. Hedl earned her JD from the University of Virginia School of Law and her BA from Emory University. Hedl, thank you so much for agreeing to speak to us today, and now the floor is yours.
Thank you so much, Pamela, for that overly generous introduction. We need to talk to our team about shortening that, but thank you so much for laying all of that out there and inviting me to join you today. It's a real pleasure to be here. Thank you to the American Economic Liberties Project and the Committee to Support the Antitrust Laws for hosting this important program and for this kind invitation. As Pamela said, I'm the Deputy Assistant Attorney General in charge of litigation at the Antitrust Division of the DOJ. And so A, it's no surprise to you that we've been busy, and B, it will also not surprise you that most of my stories begin and end in the courtroom, which is, in my view, the theater for vindicating all sorts of harms that plague us as a society. While I'm here, of course, to talk to you about the critical need for antitrust enforcement in this particular moment, given the enormous, systemic, and seemingly intractable harms we face as citizens and participants in our global economy, more fundamentally, I wanted to use my brief time with you today to talk to you about the vital role that plaintiffs, in particular, of all kinds, of all stripes, the role that plaintiffs play in making the world a safer, fairer, and more just place to live. To paraphrase the tireless plaintiffs advocate Clarence Darrow, there will always be wrongs occurring in this world, and resisting those wrongs is both a powerful and courageous act. That's what plaintiffs do, and that's what we've always done. We stand up and object to wrongs that we see occurring in the world and try to make them right. And we don't just stand on principle, because unlike in the movies where one blistering cross-examination or inspiring speech, looking at you, Perry Mason there, can suddenly win a case on its own, in the real world, plaintiffs carry and are tasked with carrying a very real burden of proof. And that can feel onerous and exacting and difficult on a day-to-day basis for those of us trial lawyers who face those challenges every day as the plaintiff on this side of the V. As we all know, plaintiffs have to do the difficult work of marshaling all sorts of evidence, building a case piece by piece, and then persuading people, often juries, who are often complete strangers to the case, that the evidence that has been marshaled justifies some form of relief, that you're asking a court to say, stop doing something that's been done, or give us some sort of compensation for the harms that occurred. Now, those seem like enormous burdens, and often they are enormous burdens, but with those burdens also come some truly awesome powers. The powers to be the architect of our complaint and the masters of our own arguments, that we can craft and amend and shape and revise to overcome defenses, but also to maximize our ability to be successful at vindicating the harms that we're trying to reach. We also have, as plaintiffs, have the power to marshal evidence and people and documents to court in a public forum in order to have public engagement as well as the judicial engagement on a particular issue. Most importantly, as plaintiffs, whether we're public plaintiffs or private plaintiffs, we have the power to seek relief from a neutral and disinterested jurist, a fact finder, usually a judge, that has taken an oath of office to fairly and impartially apply the laws, and who can simply, with the stroke of a pen, rebalance the scales of justice. In other words, our system, our unique system in America, empowers plaintiffs to literally command the room in terms of how judges and juries should resolve issues. And our system trusts plaintiffs to tell the story, to actually shape a narrative, to tell some of our great American stories. Now, we know that a lot of unlikely stories of ordinary people using their power as plaintiffs to achieve social change that ripples far beyond the facts of their own case. Those names are legendary. They include people like Oliver Brown, Clarence Gideon, Lily Ledbetter, Mildred Loving. These types of legends and the millions of others that I have not identified today command us to not just accept the shape of our law as we find it at a particular point in time, but to actually use the law as a tool and to use litigation to reimagine how those doctrines can be readapted to modern realities and our modern values and sensibilities. And so as the needs and changes of our modern life evolve, plaintiffs are not only empowered to, but are obligated to help the law adapt with it. As the plaintiff exemplars that I just shared with you and the millions of other plaintiffs demonstrate, while we have an obligation as lawyers to be faithful to the tradition and principles of the law, we also have a cherished responsibility and an obligation to remember those principles are not and cannot be frozen in time. This is certainly true in lots of different areas of law, but perhaps in this particular moment in history, no more true than in the area of antitrust. Antitrust and the issues of competition policy is an area in which we've had to confront new challenges to competition in every age as the source of American economic power has continued to change, shift, and adapt in the last 135 years. I don't need to tell this group that we all live in an era and in an age of enormous and unprecedented threat to competition. Corporate power and consolidation has already been accelerating for decades, with over 75% of US industries now having a smaller number of large companies controlling more of their business than they did 20 years ago. Let me stop there, 75%. We see that concentration across all kinds of industries that strike at the heart of our ability as Americans to build decent, meaningful lives. And those industries are vast, from healthcare to financial services to agriculture and even more. The corporate consolidation, the AELP, and other organizations identify and target really flags that these types of corporate consolidation results in real harm to real people. These aren't academic concepts. They have a concreteness in our daily lives. And so as this organization has documented, corporate consolidation, in fact, costs the American household $5,000 in lost purchasing power. And median annual compensation would be more than $10,000 higher if employers were less concentrated. But that's just the tip of the iceberg. At the Department of Justice, we've taken this rich body of data that a number of organizations and the department and the division itself have marshaled in terms of identifying the problem, to then turning around and saying, we embrace the plaintiff's duty to tell the modern stories of how competition has become threatened in ever-evolving ways, and more importantly, how antitrust law and the tools that antitrust law gives us are fit to purpose and can be adapted to take those challenges head on. So I want to talk to you about a couple of examples in which we've embraced that challenge and presented these stories to various fact finders. First, we did this, for example, when we challenged the proposed merger of two major book publishers. Now, instead of focusing on a more traditional theory, and this was the Penguin Random House Simon & Schuster matter, in this case, rather than focusing on a really traditional theory of how a merger might make two book publishers increase their market power, market concentration, and therefore the prices of books would go up, we instead shifted the conversation, instead talked about stories and staked our case in the age of creative work on how the merger would undermine creative work, how the merger would would negatively impact the diversity of stories that are available in the modern marketplace. And so at the time that we did that, there was a lot of consternation and discussion around, well, is this a proper theory of harm? And I'm here to tell you that on the other side of it, a United States District Court has found indeed it was. And creative work was in fact a valid harm that could be alleged and was vindicated there. Recently, as you may all be aware, we also tried to embrace the era of storytelling and making the antitrust harms that exist on a systemic level real on a practical level when we challenged a proposed merger of two low-cost airlines. In that case, we focused on the interconnectedness in terms of the modern cost-conscious traveler against a backdrop of a historically ultra-concentrated industry. And we talked a lot about what the choices available to our modern travelers, particularly cost-conscious travelers, should be. A traveler who values the destination more than the journey, because we're not all created the same as consumers. And that's an important part of vindicating competition and competition issues, is to make sure that the diversity of choices, again, are available to consumers. Now, on the other side of this, it's helpful to note that I'm not sure that either of those theories and either of the two merger challenges that I just talked about would have made much sense to a judicial officer 30 years ago. But I'll tell you that they were the urgent antitrust stories that needed to be told today. And so we met that moment and we told those stories. And I'm here to also report that those stories now aren't academic or ephemeral, or they're not pie in the sky in terms of what matters to the judicial officers that make these decisions. I'm here to tell you that those stories resonate. I see that the use of these traditional legal doctrines that I've just been talking about in new ways to address modern challenges occurs in private litigation all across America in really powerful and impactful ways. Whether it's fast food workers, home buyers, college students, or more, these groups of private litigants and private plaintiffs are stepping up to the plate. They're embracing their obligations as plaintiffs and their responsibilities as plaintiffs. They're demonstrating tenacity, courage, and forthrightness and fortitude in framing those disputes and seeking justice. And that matters in this modern moment. Actions like from the private plaintiffs bar and from public plaintiffs are crucial, which is why the Antitrust Division, the FTC, and other government enforcers have been ramping up our own efforts to file statements of interest and amicus briefs to support these kinds of private lawsuits. It's also really important for those plaintiffs to get their day in court and to be able to use procedural mechanisms like class actions and other procedural devices within the confines of the law and the rules of procedure to seek collective relief, because private litigation and government enforcement should and do go hand in hand. Government actions sometimes vindicate uniquely public interests, such as when criminal prosecutions help pave the way for civil accountability in private litigation, or when we take actions to block anti-competitive merger before they have a chance to harm consumers. But critically, as the judge in one of our recent enforcement actions put it in his opinion, we at the division speak for the consumers who would otherwise have no voice. That is the beating heart of our mission, but it also rhymes with your broader mission, with the broader mission of plaintiffs everywhere, to leave the world a safer, fairer, and more just place than we find it. So my charge to you today in talking about the role of private plaintiffs, in particularly vis-a-vis corporate power and the types of corporate power that this organization is committed to, and many of you in this virtual room are committed to, is to say this. We must embrace both the tradition of the law, but also the evolution of society, and find a way to meet in the middle with respect to taking that tradition and making sure that it's fit for modern purpose, such that the changes, whether it's in technology, whether it's in infrastructure, whether it's the structure of our economy, doesn't swallow the purpose and the original intent behind the Sherman Act and the related precedent that guide our antitrust doctrine today. Put more simply, my charge to you today is to understand and appreciate that power in the hands of corporations or any other entities, whether they're big or small, does not leave us powerless. The ability to serve as plaintiffs empowers us to make sure that we tell these stories in a way that exacts and appreciates real, tangible benefits to the American people. Thank you again for inviting me to be with you today, and I look forward to learning from all of you, this distinguished group of practitioners as well. I appreciate the time. Thanks so much.
Thanks so much, Hedl, for that glowing speech. My name is Lee Hepner. I am Senior Legal Counsel at American Economic Liberties Project. I just really appreciate the framing of this as, retelling our great American stories, reimagining modern realities, bringing the laws into contemporary society. And I have no problem perpetuating that lofty frame because I think it's really challenging to do so. And I think Hedl touched on that as well. I'm very excited to introduce our panel of speakers here who are among the most effective folks at doing exactly that, with proven track records of holding corporations accountable and applying the antitrust laws to advance a fair economy. Before we get into it, I just want to do a few introductions here. First, we have Greg Asciola. He's a partner at DiCello Levitt, based in New York, where he serves as the chair of the firm's antitrust and competition litigation practice. He's also vice president of the Committee to Support the Antitrust Laws, COSAL, our co-sponsor here today. And he actually began his career at the Justice Department in the antitrust division. So has actually seen many sides of this enforcement puzzle. We're grateful to have him here. Next, Deborah Ellman is a partner at Garwin, Gerstein and Fisher, where her practice focuses on all aspects of complex antitrust litigation, where she has brought several class action suits, among them many against drug manufacturers. Miraculously, Deborah has time to serve as treasurer of COSAL as well. Thank you so much for being here, Deborah. And finally, we're joined by Jamie Crooks of Fairmark, which, if I'm not mistaken, I believe is a portmanteau of fair market. And isn't that why we're here today? Jamie is a co-founder of Fairmark, pursuing targeted impact litigation that holds large corporate actors accountable for antitrust violations and a range of other harms. Enough about me. Let's jump in. I want to start off with a broad question here, which is, how would you all, the practitioners here, describe and explain the importance of private plaintiff side antitrust litigation? We just heard from Hedl. I think, there's an interesting conversation about how the goals or priorities of private and government enforcement align, where they might be different and distinct, and how, if at all, has this recent resurgence in public enforcement affected your practice? We didn't plan who to start with, but because I'm looking at them, let's start with you, Greg.
Oh, great. Thanks. Thanks, Lee. Very pleased that I was invited to talk today. And it was great to hear DAAG Doshi or Heppel. I guess that's easier to say. So, you asked why private litigation is important. I might rephrase that and say, why is private enforcement important? Because in the end, we as private litigants are enforcers. Our enforcement efforts go hand in hand with public enforcement, the government, and that's not just DOJ and FTC, the federal enforcers, but it's the states as well, and it's international. Both public and private enforcement of antitrust laws are essential to have the most effective antitrust enforcement in the world, and I think we do. And when you think of private as well, it's not just class actions, but it's also opt-out actions, individual actions, and competitor actions. The most important reason I would say for private litigation is we bring more cases. We're able to use our resources to bring more cases to the table to enforce against more anti-competitive conduct. And not just follow on the cases from the government. Of course, that's an important part of what we do. And we're always happy when the government leads and finds a case. But, when the government has a lot of things on their plate and limited resources, for example, they have to look at mergers and a lot of things that maybe don't fit as well in the private enforcement realm. That's where we can take over and offer the resources, the expertise, the skills to bring and enforce antitrust laws on behalf of private plaintiffs. And, I can list a host of cases where we have led the charge and the government hasn't gotten involved, but where you can see the alignment, and Hedl said this, is, they'll be filing statements of interest, they'll be filing amicus briefs with us, and we'll be doing the same. So I think that's a critical thing to think about. And I'll just quickly add, of course, we can get damages. And where the DOJ and the FTC can get all kinds of relief and monetary relief as well, that would go into a victim compensation fund. We, on the other hand, are going to get monetary relief and structural relief that goes straight to the victims of the anti-competitive conduct.
Yeah, that sounds right to me. I'm interested whether Deborah or Jamie have anything to add there, whether you see your cases building on public cases, preceding public cases, and when that interaction is helpful, or yeah.
Yeah, I'm happy to go next. I think that Greg hit the nail on the head in terms of resources. I saw a stat from former FTC Commissioner Slaughter in a speech in 2020. She pointed out that the FTC staff in 2020 was 50% smaller than it was at the beginning of the Reagan administration. Yet antitrust litigation is hugely more expensive. And I think more importantly, the economy that FTC is supposed to oversee and maintain fair competition in is 6 times larger than it was at the beginning of the Reagan administration. So I think the resource allocation is a key piece, and I'm glad Greg touched on that. I think the other piece that's worth thinking about is, given their limited resources, I think that the government rightly wants to be very, very sure before it brings a case. They only have so many lawyers. They're focused on mergers as well as anti-competitive conduct. They only have so many lawyers and economists looking over the entire economy related to both those fields. And so when they want to really decide to ramp up and bring a case, which involves a massive injection of resources, they have to be very, very sure. Whereas, with plaintiffs attorneys, we can sort of take a little bit more risks and push the law a little bit further in a sort of more pro-competition direction, or at least, bring cases that we think may not have a guarantee of success, but could have hugely beneficial impacts for small businesses, for competitors, and ultimately for consumers and workers.
And I'd like to just address sort of the flip side of it, and why I think that the public and private enforcement partnership is often so effective, and why we're seeing a real resurgence of that today. And that's that even though we can bring and seek treble damages, we can often have infinitely greater resources. The government has some tools that are not available to private plaintiffs. If the government issues a civil investigative demand, companies are going to answer. They have to answer. Whereas, not to bore the non-legal members of the audience, discovery is just a brutal fight and really expensive fight in the courts. So what I have seen of this waxes and wanes, this partnership, but the current environment of not quite collaboration, but mutual support, I think is really helping to push things in the right direction.
Yeah, I like the framing of it as sort of resource allocation, and it's really heartening to hear that you also see this as an additive sort of dynamic right now, where there's this supplemental authority and being exercised on both sides of the equation. But it is a resource allocation side on the private side as well, and I think as important as private litigation is, it's probably the reason that it's faced a lot of attacks over decades, undermining the private right of action, creating barriers to litigation. I'm curious how you kind of perceive those challenges, what you think the biggest challenges are to bringing a case. If it's not, the certainty of a case, and you guys have a bit more flexibility to explore kind of the riskiness of a case, what are the other challenges to kind of bringing a case and not just bringing a case, but pursuing a case fully through the full litigation process?
If I can just jump in again here.
Yeah.
A lot of the challenges are not unique to antitrust. The class action device is under siege. Defense counsel are attacking it, and the recent slate of judges are very receptive to it. The standards for getting over some of the initial procedural hurdles, like a motion to dismiss, have been raised by the court for 30 or 40 years. I think that's also cyclical, but we're seeing a sustained rise in barriers to bringing and sustaining cases. And back to the class action specifically, some of the decisions that have come down over the last 20 or 30 years have made it so plaintiffs practically have to prove their case at class action in order to survive. Those are just a few of the barriers that I would mention.
And I think one, I totally agree with everything Deborah just said. I think in addition to that, one challenge that's unique, or at least I would say almost unique to antitrust cases, is particularly when you're talking about a very consolidated industry with one or two dominant sellers or employers. By definition, when you're bringing a monopolization claim, you're talking about someone that the victim, whether it's a consumer or a worker or a small business, you're talking about someone by definition they have to do business with. They're a monopoly. They're the only game in town. And so it takes a lot of courage to sue, recognizing that they could immediately end their business relationship with you if you bring suit. So I represent a number of small farmers against large poultry producers, and in regulatory proceedings against John Deere, where they've sort of made it impossible for farmers to repair their own equipment. And many farmers have been extremely brave in being willing to step up and say, hey, this employer is not treating me right, or hey, I can't fix my tractor the way I used to. But many more that I talk to, totally understandably, talk to us off the record, but then they say, I can't go public with this because I have to deal with my local John dealership. I cannot harvest my crops if I can't fix my tractor, and they've made it so I have to go to that dealership. So I think when you're talking about highly consolidated industries, which so many parts of the American economy are today, that is another burden to bringing an antitrust case, is really having the bravery to step up to massive corporate power.
Yes. Let me add that, even today, like Deborah said, what I'll call the cookie cutter per se price fixing claim has gotten tremendously more difficult. If you think about it, I am certainly not the first to say this. Plaintiffs, say in a class action, have to win 5 times.
Yeah.
We have to defeat a motion to dismiss, and I'm going to put aside a motion for reconsideration and maybe a 12C judgment on the pleadings motion. But we got to win the motion to dismiss. We have to then get a class certified. Then we have to go over the inevitable 23F appeal to that. We have to win on summary judgment, and we have to win a trial. Defendants only have to win one set of those, and that ends the case. So our struggles out of the gate are immense. And I don't want to sound defeatist, but it is, in my mind, every decision by a judge makes our job harder. Even if it's for you, then you're at least just breaking even. But more often than not, judges are chipping away little by little, making it extremely difficult to get over those 5 hurdles. I mean, we face these challenges every day, and I think, plaintiffs, both the government and the privates, do a tremendous job. But it does get complex and difficult. But thankfully, we keep fighting and fighting and fighting.
I mean, I assume you've experienced, different types of judges. I know it's not a monolith, but, I assume that there are some judges that actually wrestle with this as well, who don't necessarily want to meet the merits of a case at the dismissal stage. But do you how do you interact with different judges? We know that the Chamber of Commerce will judge shop till the end of time, but how do you engage with different judges on that basis?
I think I'll go first, I guess. I think, at least in my practice, we would much prefer, and this may not have been true 15, 20 years ago, but today I would much prefer a smart judge to a less intelligent or sort of more, simplistic thinking judge. I care much more about that than I do about liberal versus conservative, because I think in large part because of the work that Economic Liberties and COSEL and other groups have been doing the last several years, there really has been an understanding on both sides of the aisle that this is a serious problem. And so I think that the partisan breakdown that may have existed 15, 20 years ago is not so prevalent now. But what I do think about is what I love is a judge who's willing to, by definition, they're not an antitrust expert, except in very rare cases where they happen to do that before they were appointed to the bench. Judges are generalists. You'll be bringing a case in an industry that could be very complicated and a contracting regime that is very hard at first to understand. And then you're going to be ultimately ruling on whether basically the way business is done in that industry is lawful, and that's a heavy burden on the judge. And so from our point of view, we care much more about finding judges who have the confidence and the sort of willingness to dig in, to really understand the issues, and aren't shying away from being the first to say, no, this kind of practice, I don't care if all of the big five have contracted this way the last 20 years. This is the case in front of me, and it's not lawful for XYZ reasons.
And as long as we're talking about barriers, I don't think we even touched on, arbitration clauses and class action waivers as a whole separate type of barrier that the private market has really created to relief. And I'm sure you all have encountered that many times in your practices.
Well, I should have added that to my list of things that are not antitrust specific, because these mandatory arbitration clauses and class action waivers are keeping people out of court or making it more expensive to litigate in consumer cases, in employment cases, in antitrust cases. I think it's a real problem. And
I can echo that. In many cases, ARB clauses and class action waivers are death knells out of the gate. I think, my firm has found what would be very good antitrust cases, but for arbitration clauses, we could not bring them. It really has to be an unconscionable arbitration clause, and there's few and far between that you'll find those. So we actually have to reject cases out of hand that are what we would describe as merit-worthy antitrust actions out of hand because of arbitration clauses. And it's disappointing that the first thing we do when we're doing an independent investigation is look for an ARB clause. So then we don't have to waste time delving into the facts and the law to potentially find a case. I mean, we have to look for the arbitration clause. We find it, it's very disappointing.
And
I just want to, sorry, go ahead.
Add very, very quickly to that. But I think, like every plaintiff's attorney, arbitration clauses and class action waivers have been a huge problem for us as well. I will say, going back to the original sort of theme of public-private interaction, that is definitely when we pick up the phone and say to DOJ, FTC, or to a state attorney general, hey, they've got these contracts locked up, so consumers can't bring this as a class action, but you're not bound by this arbitration clause. You're not bound by this class action waiver. You should really take a look at bringing a case on behalf of the citizens of your state or on behalf of the federal government. And they've really, especially in the last 3 years, really brought some very, very big cases that I think were sitting there, but we couldn't bring because of these kinds of arbitration clause problems.
That's an excellent point. And one piece of bright light I would offer is that some very creative lawyers are turning those arbitration clauses back on the heads of the corporations that are promulgating them. And so it's becoming almost more like a mass action. And they're lining up plaintiffs, and they're taking the arbitration clauses at their word that whoever is defending has to pay the fee or has to pay the fees. And it hasn't, I don't know that it even lends itself to becoming widespread, but it has been effective. And the arguments that have come out of those who have promulgated such clauses are amusing and quote-worthy.
Love that. As long as we're talking about barriers to entry, let's also talk about how you find cases in the first instance. And once you get through that filter, if it is a filter of having an arbitration clause or a class action waiver, where are you finding interesting cases? Where do they come from? Do they walk in your door? Are you seeing them in the news? And this is also an opportunity, I think, for you guys to talk about some of the cases that you're personally proud of, or some of the cases that you are seeing out there that you find particularly interesting.
I'm happy to get started. Putting aside the government follow-on cases, which is a source, I have to say my gut tells me over time, and I've been doing this now for just about 30 years, is that back then, I think most cases were coming as government follow-on cases. But nowadays, I feel most of my cases and the cases I see others file are independently investigated. And brought by private litigants. So that's an interesting turn. Of course, I have no empirical evidence for that. It's just my gut. But also, we find cases from international enforcers. We see what they're doing abroad, and we then investigate the potential either impact on the United States, or maybe that very same conduct is going on in the United States. Like you said, Lee, the news. colleagues might come to us with a case that might be in a smaller firm and need antitrust expertise and the resources we have as a larger firm. And then we have people walk on our door, just like you said, a lot of people walk on our door. Clients will come to us with a complaint, and just individuals will pick up the phone. And I'll just quickly go to just a case that is an interesting case. That was a private only case, and that was our varsity cheer case. Mm-hmm. That we got from the news. There was something on YouTube about varsity cheer, and it was a monopoly case. The plaintiffs were gyms and individuals, and the case involved competitive cheerleading. Believe it or not, it's a multi-billion-dollar business. 4 million kids participate, athletes, I should call them. These are those 2-minute routines with amazing acrobatics and skills. But anyway, the allegations were that this varsity cheerleading and the U.S. All-Star Federation that oversees it were monopolizing the market for these cheerleading events. We brought the case with a few other firms, and there was no government action. And what was great about this case was we got a $43.5 million financial settlement, but also tremendous amount of structural relief to change the industry, to make it more competitive, to allow for competition to get in, to reduce the cost to the families as far as registration fees and purchasing apparel and whatnot, and the gyms who had to pay to put on these events. So we looked at it as a great victory for private litigants in the very difficult space of monopoly in Section 2.
And I just love that varsity cheer case because I think it demonstrates that this is a problem that occurs across all sorts of industries. It's not just the ones that are making the big headlines from day to day, but varsity cheer, who would have thought? But it turns out that you find monopolies in all these little pockets.
That's exactly it. Who would have thought?
But that's a really good point, Lee, that this does affect everyone, and it's not just the tech and sort of airline cases that are making a lot of getting a lot of play in the press right now, which are incredibly important cases. Particularly, I think the tech cases, not just from an economic justice perspective, but also from a political and First Amendment perspective, where the voices that can be heard and seen can be affected by these mergers and monopolies that block access to other outlets. But this doesn't, the grocery store, drug prices, healthcare, hospital mergers, rent, but on the flip side, salaries ranging from really senior, sophisticated tech executives or physicians, healthcare providers, to fast food workers. So this would be, the flip side, which is something that private plaintiffs and DOJ have both been pushing. Greg could talk about this because I know he's involved in a specific case involving airline manufacturers, if I've got that right. But where the hiring entities are collaborating to limit freedom of movement of jobs by agreeing not to pay workers in certain tiers more than each other. And that's just sort of a really fundamental daily life issue for everyone.
I think the only piece I'd add to that is that these days, I think both because of the nature of the economy, but also I think the sort of high burdens of proof we were talking about earlier, how difficult it can be to prove a case. My firm does a lot of work in healthcare, both on the hospital consolidation side and on the PBM and drug manufacturer side. And we have a full-time team of non-lawyers who, in my experience, are oftentimes much, much better at building cases than lawyers in many respects, because a lawyer looks at something and says, oh, it doesn't fit exactly in this bucket that there have been 10 cases about. Whereas a non-lawyer will say, hey, this looks pretty messed up. I think we should look. And so we oftentimes will work with academic researchers, with nonprofits in terms of obtaining data sets. So for instance, in healthcare, where we can look at, and thanks to a law passed in 2020 that the Biden administration has really ramped up enforcement of the hospital price transparency rule. So before 2020, hospitals did not have to tell you before you went to get care how much things cost. Now they're required to, and after resisting for only 2 years, it actually is up online now and usable. We have a full-time health claims data analyst who comes from a tech company who is able to look at given geographic markets and say, hold on, the price of a CAT scan, which is really like an assembly line procedure, and I'm not even talking about reading the CAT scan, the price of just pushing the button is 50% higher at this hospital than it is at a higher quality hospital down the road. How can that make sense? And then you dig in more, it's like, oh, well, that's because they have a monopoly level market share, or they control this one market that every insurance company needs, et cetera. And so I think for my firm, at least, data analysis on the front end has been very, very helpful. And then when you see things that just no functioning market should allow, like those kinds of price differentials that cannot possibly be based on quality, we know that something's wrong, and it almost surely goes to the core of the competitive process. And then we start our sort of qualitative research with our non-attorney researchers, and then we get the lawyers involved to say, okay, exactly how is this unlawful?
So I would agree with both of what Greg and Jamie said about finding cases, but I would also add that sometimes it's just walking down the aisle and seeing that products are priced exactly the same, or you're looking for a book and it's the same price on every, an ebook, and it's the same price on every platform. And I think a really interesting area that's new, and I think we're going to see more cases in this area, is algorithmic pricing. And so the idea that big landlord or management companies are sharing their data and setting rent prices on that basis is that there's a case underway right now. And I know there's another case that's very similar, and I know Greg's firm is involved in it, involving mobile home pricing, and it's the same idea, and it's ideal now almost exclusively in pharmaceutical cases, and it's very easy to see where the prices are outlandish. I mean, one of the cases we're involved in right now is EpiPen, and those stories, some of it came through just the news and through parents and through congressional investigations, but to have the price of something, increase 9,000 times is a real red flag.
And just so the folks in the audience who may not be familiar with sort of the algorithmic pricing, it's a huge and growing problem. The industries will defend this by saying, "Oh no, I'm just subscribing to an industry program, an industry platform that tells me industry statistics. This is normal. It's normal for me. I'm just checking on the prices of my competitors. That's competitive." But in the landlord case that Deborah mentioned earlier, to subscribe to that system, you had to tell it everything you're charging, and then it wouldn't just tell you what your competitors are charging, so you could ostensibly try to beat it. It would say, you should charge this price, and it would be the same price that they tell every other landlord. And this was in the region, and this has been shown to have driven up rents by about 20% in regions where this was used. So it's not just normal, oh, I look and see what my competitor's doing so I can beat him. It's the algorithm is telling me what I'm supposed to charge so that both myself and my competitor can both do better at the expense of consumers and tenants.
Thanks, Jamie. And in fact, the same people who are aggregating and then sharing the data with would-be competitors are going out as secret shoppers to make sure that the subscribers are in fact adhering to the prices that are suggested.
They will report you to the cartel if you charge less. If you have the gall to charge less than they told you to, they will. Yeah, exactly. They investigate, deviances from the rule. It's really crazy behavior.
And this is a line of cases where the DOJ is out there talking about algorithmic pricing and more basic information sharing. And that's the mobile home lots case that Deborah was referring to that we brought. They're out there leading the charge, talking about how this is anti-competitive. But for the moment, it's the private litigants that are leading the charge and actually bringing the cases. And the DOJ is participating in that through statements of interest in a number of the cases, where they're filing that before the courts to make sure the law is correctly applied.
And I believe one of the things one of the things they're saying there too is that these algorithms can actually facilitate collusion in less concentrated markets, which I think is another kind of way of thinking about monopoly power and how corporate power manifests, is that you don't even need a concentration market for these algorithms to perform their function. There's so much to pick up on here in this conversation. I feel like we could sit with this for a long time. I mean, I also like the callback to Ms. Doshi's comments about storytelling and how often it starts there with an observation, and then how do you tell the story, and then how do you apply the law and adapt the law and evolve the law to fit that narrative. But I want to, kind of move towards our final question here, which is, I think, an optimistic way of, hopefully an optimistic way of closing out this conversation, which is that, litigators are not necessarily policymakers. You guys are not necessarily legislating laws. Sometimes that happens after a case, or, it's kind of a separate parallel process. But if you could snap your fingers and break down some of the barriers to bringing these cases in the first place, where should we be thinking about making these cases more viable? Where can lawmakers and regulators, some of whose staff or themselves might be in the audience today, kind of be picking up on this conversation in actionable ways?
Well, if I get to snap my finger, arbitration clauses are gone. That would be a start. One thing, and Jamie touched on this, and I think Hedl touched on this too. I'm not sure this is regulatory, but we do want to perhaps see more informed judges on antitrust matters, in the sense that maybe there could be, some judicial education where we have jurists that are, keen on antitrust issues, antitrust law, because it is so complex. And I think that would certainly, help to further private litigation. I mean, because that is an issue, because part of our job is to educate judges and educate potentially juries in a very short period of time. I probably have said this story before. I mean, my mother for 30 years asked, what do I do? And I explain, and she says, I don't understand this. I said, I want to go to the store and see 12 jars of tomato sauce, and I want them to be all the same price, so I could just pick my favorite one. Boy, would my life be easy if I could do that. So what does that mean? Like, we have a lot of work to do to educate people about antitrust. It also means I can't file a case in Connecticut because my mother might get on the jury. But I think education is key.
I totally agree with that, Greg. I think also with antitrust in particular, whether it's a cartel, where by definition there's a reason that the old saying is a smoke-filled room. These agreements are almost definitionally secret, and only the members of the cartel know that there's agreement. Oftentimes it's not in writing. Very, very difficult for an outsider to get their hands on the smoking gun before filing. Similarly, with monopolization cases where there may not be collusion between competitors, oftentimes the really anti-competitive conduct that goes on are in contracts that the dominant supplier or the dominant employer, et cetera, will have confidentiality clauses. So again, the ultimate consumer who's bearing the brunt of these higher prices is not even allowed to see the contract that is setting the price that they pay, or seeing the other sort of mechanisms in there, the contractual mechanisms that might be reducing competition. If you combine that with the higher pleading standard that courts have imposed across the board on plaintiffs, but particularly on antitrust plaintiffs, I think you have a real disconnect there, because very rarely is anti-competitive conduct overt. It happens usually by industries or entities like the NCAA, who just kind of thought they were immune forever and did things out in the open. But for the most part, it's behind the scenes, and you're not going to have the key document beforehand. So I don't know whether this is a legislative fix or something that judges could be better educated about, but understanding that while we still have a burden we have to meet in terms of showing that the anti-competitive conduct is plausible, we should not be expected to have the, hey, let's all agree to raise prices by 15% on this day, because we're not going to have that before we file. And expecting us to have that before we file does a huge disservice competition.
I would add 2 points. I agree with everything that Greg and Jamie said. One is, in Europe, they have a different and more lenient, well, maybe more lenient standard, which is the abusive dominance standard. And so we've seen certain states moving to adopt that standard. I don't know that, California is unique. They haven't actually done it under the rubric of antitrust. And I know New York, the legislature has been considering it, but I don't know that anything has been formally adopted. But I think we could have another whole session on these different standards for cases. But I'd like to see that adopted. The second thing is a little more hands-on. Sometimes in times of crisis, the standards are relaxed. So during the COVID pandemic, companies could get waivers to share health information. There's a big issue right now about climate change, and can companies share information for the common good? After 9/11, it was the airlines. I think there has to be more monitoring of what happens when the crisis is no longer so immediate.
I think that's a good way of kind of wrapping us up there. Just a couple of points of information too. That abusive dominance standard, that is a bill that was moving in New York, and I believe is still a live effort. There's a similar bill in Pennsylvania. California is undergoing a study on that. So that is a trend that we're super interested in as well. On the pleading standards, our organization, Economic Liberties, has put forward model price fixing legislation that tries to reorient and right-size those initial pleading burdens to make it a little bit easier to get to the discovery phase of litigation, because you don't know all of that information up front. So I think that's something that we're also right there with you on. I am going to close it there and turn it back over to Pamela Gilbert. But thank you again to all of our panelists. It's been a real joy having you all here.
Thanks for having us.
Thank you.
Pleasure.
Thank you so much. And boy, I've just been sitting back and relaxing and listening, and I've learned so much. Thank you, Hedel and Lee and Jamie and Greg and Deborah. That was really fabulous. I am not going to spend a lot more time, but I'm going to wrap up stepping back a little bit after those very, very helpful, more in-depth comments about private litigation, and then end up with my own personal pitch about what we can do on the public policy and to support private antitrust enforcement. So I'm going to start with a quote from the Supreme Court from back in the 1970s, just reinforcing how important the antitrust laws. Supreme Court stated, "Every violation of the antitrust laws is a blow to the free enterprise system envisaged by Congress. This system depends on strong competition for its health and vigor, and strong competition depends in turn on compliance with antitrust legislation." Now back to me. That compliance depends on strong and effective enforcement. And as we've heard a lot today, strong public enforcement is vital, but the government will never have enough resources to enforce the antitrust laws on its own. So over 100 years ago, Congress recognized this and passed, we had the Sherman Act and then also the Clayton Act. And in the Clayton Act, there's a private right of action that enables victims of antitrust violations to sue the wrongdoers in federal court. But not only did Congress provide this federal antitrust remedy, it added a substantial incentive to encourage victims to act as private attorneys general to enforce the law. So as you've heard, the Clayton Act provides for triple damages plus costs and attorney's fees. It's one of the strongest private rights of action that exists in the law. And the existence of a strong private right of action does a lot of things. One, it allows the government to focus its resources on areas where it's uniquely positioned. For example, to bring criminal cases, to bring cases where they can provide amnesty to cooperating defendants, or to bring cases where you don't have a lot of monetary damages, but a very strong need for injunctive relief. And in addition, another advantage, private antitrust enforcement costs taxpayers nothing and delivers enormous benefits to consumers and small businesses. And there's been academic research to back this up. So for example, law professors Bob Land and Joshua Davis conducted 2 studies of private antitrust litigation involving a total of 60 antitrust class actions that were settled in the 15-year period between 1992 and 2007. The study focused primarily on large cases that returned at least $50 million to the class members. And the purpose of the studies was to assess whether private antitrust enforcement does in fact deliver its purported benefits, and that is compensating victims of antitrust violations and deterring anti-competitive conduct. And they did conclude that private antitrust actions recover billions of dollars of compensation, and the cases have an extremely strong deterrent effect. So in particular, the studies found that the private cases recovered about $35 billion for the victims during that 15-year period. In contrast, over the same time period, the Department of Justice imposed fines on wrongdoers of about $8 billion, which is less than 25% of the private recoveries. There have been more recent empirical studies with similar findings, one by Huntington Bank and UC Law San Francisco, finding $32 billion in antitrust class action recoveries during the time period of 2009 to 2022. The Land-Davis studies also found that the 60 cases studied had significant merit. They were not in any way frivolous or dubious. The studies concluded that private enforcement is effectively the only way for victims of antitrust violations to be compensated, and that the deterrence effects of private antitrust enforcement are underappreciated and remarkably strong. So I know that a lot of folks in our virtual room today have been involved lately in developing and supporting legislation to establish new and stronger antitrust protections for consumers and small businesses. And many of these proposals also enjoy bipartisan support. And I applaud anyone who's involved in these efforts. I've been working on antitrust policy for decades, and I've never seen this level of positive and cooperative activity. And it's fabulous to see. So I'm going to end by making a pitch to all of you that are involved on this policy end, that if we are going to be establishing new antitrust or antitrust-related protections, those bills also should provide a private right of action, a meaningful remedy for victims of the violations to enhance the enforcement of the new laws. And I'm going to argue that to do that most effectively, you might want to look at going in one of two directions. The easiest and simplest is to simply amend the current antitrust laws. And so if you add protections to the current antitrust laws that are in existence, you don't have to provide a new private right of action because it already exists in the Clayton Act for the federal antitrust laws. And so that's an easy and clean way to do it. The other way is if you are drafting legislation that's outside of the antitrust laws but are in the antitrust context, you should put in those bills a private right of action, but it should be modeled after the existing private right of action in the Clayton Act, which, as we've discussed, has very, very strong private attorney general provisions in it. So the Clayton Act has been around for over 100 years. It's time tested. It's been upheld over and over again by the courts, and Congress hasn't weakened it in over 100 years. It's a proven commodity. And so it's a great model to use. And then I would also caution that if you're going to create a new private right of action in the antitrust context, but have it be weaker than the current private right of action that we have, you could be opening the door to a conversation that we might not want to enter into about, well, should we be similarly weakening the existing private right of action in the Clayton Act? So that's my pitch. And with that, I'm going to close it out. Thank you again for tuning in. Thank you to everybody who spoke. And AALP and COSAL specifically, we thank you very much for being here today. Thanks.